Welcome, everybody, to sort of a special edition of A Better Conversation, a podcast put on by Better Dallas. As always, I'm your host, Chris Clement, joined by the man, the myth, the legend, the beard, and the capitalism pullover sweatshirt, Mr. Kyle Mason.
Yes, good evening. I'm glad that we can meet up, but it's probably good we didn't because I'm feeling a little under the weather and it sounds like you might have something going here soon too.
I am recovering. This is the
Okay.
best my voice has sounded since last Thursday.
Oh gosh.
So it's been a great time. And I'm a trial lawyer. Yesterday, I had an all day, a 9 to 5 Zoom hearing, which was essentially a mini trial, and was doing my best to hold on to my voice. So this is as good as it sounds. But speaking of legal things, now originally we weren't going to be broadcasting or putting out a podcast this week, but massive news in the state of Texas broke, and we decided that hey, we've got to address this. And today, there was the opinion came down in the challenge to the Texas congressional district maps. Now,
Mm.
there had been really an ongoing lawsuit that had been going on for quite some time, challenging even the 2021 Texas maps. But when these new maps had come out, the parties that were in that initial lawsuit continued pressing. And there was what's called a preliminary injunction that was sought by the plaintiffs in this case, which are a bunch of groups like it's titled the League of United Latin American Citizens et al. So there's a bunch of minority focused voter groups, things like that, that filed the lawsuit. So they challenged the new Texas maps, the 2025 congressional maps. For those of you that weren't aware, you're probably under a rock, but there were new congressional maps that were drawn in the state of Texas this year. It is atypical that that happens. Usually here in Texas, we adopt new maps every 10 years after the census. So what will happen is we'll have a census, then the next legislative session, they'll use the updated information from the census to redraw lines for all of the election districts in Texas. There was a call by the Trump administration to increase the number of Republican representatives in Congress. The state of Texas obliged and added 5 more Republican leaning congressional districts. However, they were challenged. These maps that were adopted in the special session of the Texas legislature received the challenge from these voter groups. And today, a three judge panel in the federal courts in the Western District of Texas in El Paso agreed with the plaintiffs and said by a 2-to-1 vote that the 2025 congressional maps cannot be used in the upcoming elections. This is a preliminary decision. It's a preliminary injunction. There still could potentially be further litigation on this and appeal to the Supreme Court, potentially a trial on the merits. This is still ongoing. But as of right now, as it currently exists, based on this 160-page opinion, the congressional maps that were adopted this year by the state of Texas cannot be used. Kyle, I've got to ask, what was your first response when you heard that news?
My first response was I wasn't surprised, and then I also love that almost every headline had Trump appointed judge in there.
It did, and that's important because the U.S. District Judge Jeffrey V. Brown was ostensibly the author of this opinion, although it was a 3-judge panel with another judge, senior U.S. District Judge David C. Guardarrama. I probably said that wrong, but it's okay. And then U.S. Circuit Judge, so appellate judge Jerry E. Smith. Now, to Kyle's point, Judge Brown is a Trump appointee, right? And not only is he a Trump appointee, but he was a Texas Republican judge. He was on the Texas Supreme Court as a Republican, and he was one that authored this opinion. Now, of course, the other judge, Judge Wadarama, he was an Obama appointee. Not a huge surprise there. Personally, it broke my heart because he has ties to Deming, New Mexico, and Las Cruces, New Mexico, which I do as well. So I was sad to see a Southern New Mexican involved in this. And the only dissent, the third judge of the panel which dissented, appellate Judge Smith, which actually foretells maybe a good future for this case. He dissented, he disagreed, and he is a Reagan appointee from 1987. So all of you out there that want to disdain older members of the judiciary or things along those lines, he was the only one that said that the Texas map should stand. Take that as you will.
Yeah, no, that's good. It's frustrating as a Republican because yes, we want to uphold the rule of law and we want the courts to remain untouched, but it's just like it makes you bite your teeth when it's just when Trump, if he tries to order, you know, softer toilet paper, a federal judge will stop it. Like immediately, they'll come out of the woodwork. Everything he does is stopped by some kind of activist judge. But then something like this, something that helps the Republican Party, you'll still have dissent from Republican judges, and that not that I want that to not happen. I want the rule of law and everything to be honest and be upheld, but man, it is frustrating.
Well, this is one that if Texas Republicans had listened to Trump, and I'm saying this based upon the opinion here, this is not my editorializing, but this is what's in this opinion. Had Texas Republicans just listened to Trump and followed his instructions, this might have turned out much differently. So, Kyle, I don't know, do you want to get into this thing?
Oh yes, absolutely. Yeah,
Okay.
let's pick it apart because our short conversation, just in our very short conversation, the deeper points that you were talking about, they're not being pulled apart in these articles. It's just very much headline, short snippet, and then on to the next thing.
Well, I love this stuff, right? This is what I do for a living. So this is straight up my wheelhouse. I do constitutional law. I'm on the Texas State Bar's board for our civil liberties and civil rights section. So this is all near and dear stuff to me. When I was in law school, one of my papers that I wrote for one of my legal writing credits that I had to take had to do with Texas election law and things along those lines. So
Hmm.
this was supremely interesting to me. I will say, just to kind of give the overarch for everybody, three-judge panel, two said that this should be struck down or enjoined in a preliminary injunction. We had a whole podcast on those with JJ Koch. You should check that out to get more details on this. And then there was one judge that dissented, which meant he disagreed. Ultimately, what the panel said was Texas's maps cannot be enforced because they were drawn on racial grounds. So you are not allowed to gerrymander. You're not allowed to draw your electoral district maps and lines, boundaries for race-based reasons. That is unconstitutional. And there's some statutory claims, but also constitutional claims. I think what probably matters the most. What this court found was, obviously Donald Trump made the call for them to add more Republican seats in Texas, and
Yeah.
Texas was going to add 5 seats. Had Texas, had the Texas legislature just gone down there to Austin and said, Trump's calling for 5 more seats. We're going to redraw these lines so we can have 5 more Republican congressional members. Had they just done that, this case probably would not have gone the way that it did. Well, it certainly wouldn't have gone the way that it did, but it most likely would have stood up. Because as the opinion here points out, partisan gerrymandering is absolutely constitutional. If you're redrawing lines or if you're drawing lines for the purpose of partisan districts, you are allowed to do that. That does not violate the Constitution or any other election law. You only get in trouble when you do partisan gerrymandering if it has the indirect effect of disenfranchising minority groups. Where you take them out of their areas, you draw them into weird districts, or lump them all together, to where you're sort of diluting the impact that they would have on the election. You can't do that on race-based reasons. You can do that for partisan reasons. So here's what happened, and honestly, this is, you want to talk about. I mean, this is taking a bazooka to your own foot, not just shooting yourself into a foot. Like this, I don't even know if bazookas even are used anymore in the military. I don't know. This is a heavy artillery to the leg, sort of thing. So This opinion extensively quotes Governor Abbott, members of the legislature, um, a letter from the Department of Justice, all of these things to show, well, time and time again, legislators in the state of Texas said that the reason they were drawing these lines was because they needed to change the racial demographic of some of these districts. And really, the linchpin in all this was a letter written from the Department of Justice addressed to Governor Abbott and addressed to Attorney General Ken Paxton. And the subject line of this letter was unconstitutional race-based congressional districts, Texas 9, Texas 18, Texas 29, and Texas 33. The gist of the letter are there are these things that were called coalition districts. And these coalition districts are called that because no one race has a majority of the voters over 50%. Sort of, we would think about this as like a plurality. You might have 45% Hispanic, 40% white, and different races from there. No one's over 50%. Those were being called coalition districts. Now, there was a case involving a case called Petaway versus Galveston that was decided in 2024 by the Fifth Circuit. And in that case, it talked about how some of these coalition districts can absolutely run afoul of the Voter Rights Act and run afoul of the 14th Amendment, and be a race-based district. The concern there more being, again, diluting racial groups so that they can't, have a full impact on an election.
Hmm.
What the DOJ said is, well, Texas has these coalition districts and they're unconstitutional. In Texas, you need to redraw the lines so that you can create race majority districts or single race majority districts. So Texas acquiesced, right? Texas agreed. And Governor Abbott called for creating specifically more Hispanic majority districts. So, right, like almost like the reverse racism DEI sort of idea, right? It's not that we're out there trying to create more white majority districts because evil white Republicans. Abbott was saying, let's get more Hispanic majority districts. Let's take these coalition districts and redraw the lines so that we have a majority of Hispanics in some of them. Now, this DOJ letter, this Department of Justice letter that the Trump administration sent was absolutely eviscerated in this opinion. And I want to quote a line or a couple of lines from this opinion that was released here today where they talk about the DOJ letter. The court says, and I quote, it's challenging to unpack the DOJ letter because it contains so many factual, legal, and typographical errors.
Hmm.
And I can confirm that this letter does have typos in it, which is astounding to me that the Department of Justice can't use spell check or Grammarly or something like that before sending off a letter to redraw congressional maps, sending it to the governor and the AG's office.
Bad,
Bad.
bad, bad.
So to make it even worse, the opinion goes on to state, indeed, even attorneys employed by the Texas Attorney General, speaking of Ken Paxton, who professes to be a political ally of the Trump administration. I don't think anybody denies that Ken Paxton says that. Well, apparently, attorneys employed by Ken Paxton, and I quote, describe the DOJ letter as legally unsound, baseless, erroneous, ham-fisted, and a mess. That's how the AG's office described this DOJ letter. Long story short, going into the legal analysis, not to bore people, the three-judge panel decided, or at least two of the three judges decided, that the DOJ completely misinterpreted Petaway. And Petaway did not rule that a coalition district in and of itself was unconstitutional, just that it could be unconstitutional. That if forced to make a coalition district, that could be unconstitutional. But if a legislature voluntarily and for race neutral reasons created such districts, that would be acceptable. That is probably the thing that blew this whole map up, was this, I will say, generous interpretation of Petaway that the DOJ, this is my editorializing, in my opinion, sent to the Texas legislature to give them some political cover for redrawing the congressional districts.
That political cover was, I mean, I missed it. I did not realize that there was a letter from the DOJ to Texas to help with political cover. I don't think anyone in America that started hearing about redistricting was like, well, there was a DOJ letter and they got to do it. Their hands are tied. Like they gave them 0% cover and it gave them 100% fail rate as of right now. We'll see what happens on appeal. The whole thing has just been completely messed up. Absolute dumpster fire.
So, speaking of this dumpster fire, I want to read some additional portions of this. Not to have story time with a better conversation, but I think quoting some of this is important for people to understand. Talking about the DOJ letter, this opinion states the DOJ letter is equally notable for what it doesn't include, which is any mention of partisanship. Had the Trump administration sent Texas a letter urging the state to redraw its congressional map to improve the performance of Republican candidates, the plaintiff groups would face a much greater burden to show race rather than partisanship was the driving force behind the 2025 map. But nothing in the DOJ letter is couched in terms of partisan politics. So, what this court said is this letter expressly told the state of Texas to redraw the map for race based reasons. That's sort of on its face unconstitutional. You
Right.
can't do that. That violates the 14th Amendment. And
Yep.
the court specifically is saying here, hey, had the Trump administration, had the DOJ just sent a letter saying, can you do this so we can have more Republicans in Congress? That probably would have been fine. So I I I thought that was very telling. Another thing that this opinion does in its 160 pages is it goes into detail statements made by Governor Abbott and members of the Texas legislature. So one of the things that it talks about, and again, this whole thing ties all back to this letter. So again, I want to quote this opinion. It's quoting Governor Abbott when he was proclaiming that this redistricting was going to be added to a special session. It says, and I quote, legislation that provides a revised congressional redistricting plan in light of constitutional concerns raised by the Department of Justice. Like that is what the legislation was. That's what Governor Abbott described as like part of the purpose of doing this. And the opinion goes on to say the governor shared, or at a minimum, wanted the legislature to take legislative action to address the Department of Justice's concerns that districts 9, 18, 29, and 33 were unconstitutional because of their racial makeup. So
Yep.
again, the court here is specifically quoting to Governor Abbott and discussing why this was even going to be considered by the legislature and saying, hey, you're citing this DOJ letter. It's all based on racial makeup. And again, the the governor in part was wanting and it expressed an interest in creating more Hispanic districts. So this is the opposite on how often these things go. Usually the concern is that you're creating more white majority districts, right? You're giving minority groups only a handful of districts where they're the majority, so they can only pick a few representatives, and then you're otherwise drawing district lines so white people are the majority. Like this is the stuff that the Voting Rights Act, this went all the way back to like Reconstruction in the Civil War, all that sort of stuff, Jim Crow era. Here it was the exact opposite. Here, the stated intent of Governor Abbott was to create more Hispanic majority districts. And the legislature did that, and they even created a black majority district as well. But I guess, yay, color blindness. This three-judge panel said, it doesn't matter that you did this to the benefit of certain, majorities for minority groups in certain districts. That's still a race-based reason for redrawing the lines. You can't do that.
Yeah, this seems a little tricky. I mean, obviously, I'm sure there's um, teams that do this, but when you talk about not having drawing along race lines, but it can be partisan lines, it's kind of tricky because, for instance, black voters tend to vote Democrat. And so it's like, well, I can draw it along partisan lines, but if I draw it, how is that legally differentiated? Does that make sense? Like if you have a heavy black district, it's kind of like, well, you put all the black people in this district. Well, that's a Democratic district, though.
So, and that's a great question. That's what usually, so I mean, those were some of the challenges that were raised to the 2021 map was because this is how it usually goes. Usually the fight isn't, hey, we're doing this directly on race. It's
Hmm.
usually an allegation that it indirectly has some sort of racial dilution or disenfranchisement. So it's a matter of, oh, Republicans are drawing what they believe to be Republican majority districts, but in doing so, it's having the effect of negatively impacting minority communities. So, like, we saw challenges to this the last two times Texas redistricted. Back in
Hmm.
2011, there was this sort of issue, and in 2021, there was this sort of issue. Back in 2011, we were still under the Voting Rights Act, and Texas still had to have pre-clearance to change any of its election laws and stuff like that. So it had to go through a pre-clearance process, and that process actually delayed the Republican primaries or the primaries in general in 2020, or I'm sorry, 2011, 2012. 2021, there was a Supreme Court case in the interim between 2011 and 2021 that did away with the need to do pre-clearance under the Voting Rights Act, basically saying that, hey, the racial discrimination that was the reason for pre-clearance was long ago in the past. There's no ongoing evidence that the state of Texas and other states that had to have pre-clearance are still doing any of that stuff, so they no longer have to pre-clear. So
Hmm.
now what happens is once the maps are released, you'll get groups like the plaintiff groups in this case that will just file the lawsuits challenging them, claiming that they're racially discriminatory.
Okay.
So,
Interesting.
so to your point, in the past, they might create a Democrat district, and by effect, it might be majority black. But if they can prove in court that the race had absolutely nothing to do with how they drew the lines, and they were literally just looking at voting records and trying to identify, strong Democrat voters, and they wanted to put them all in one district, that would be okay.
Hmm. Okay.
So, yeah, usually you're having to show, well, they really were doing this for race-based reasons, and you have to do indirect, um, deductions to get there. Here, this court is saying we don't even have to do that because, like we talked about, the DOJ letter, Governor Abbott, and then it goes in and talks about what some of the members of the legislature said. It's okay, this is just pretty obvious on its face. You guys are telling us that you're redrawing the lines. Um, so, they quote, press statements from Governor Abbott. One of the press statements And the governor specifically says this is to remove coalition districts from the congressional map, and it provided the legislature with the opportunity to replace those coalition districts with majority Hispanic districts as opposed to single race majority districts more generally. So it's specifically to have more Hispanic districts. That was this court considered that as a strike against these maps in the state of Texas. And then you had they had comments from Speaker Burrows. They had comments from Representative Alverson. They had quotes in here from Steve Toth, even an interview that he did, um, where they just over and over and over they were agreeing with the DOJ's letter and the need to comply with the DOJ's letter. I mean that they literally the only thing that Toth talked about was the quote they have here is him saying it was required of us to do it in response to Petaway to get compliant. And that's him directly referring to the DOJ's letter and assertion that Petaway did away with these coalition districts. So this crap letter sent to Texas and the Texas legislature and the governor and the attorney general and relied upon by them is literally the thing that is the smoking gun to burn this whole thing to the ground.
Can they come back, do the exact same thing, but say this is for partisan reasons now?
I mean, probably they can't draw the same maps. They'd have to draw new maps. And then because the problem is that they've already drawn these boundary lines and have done it here expressly for race-based reasons.
Mm-hmm.
If they were to go back later and do it and do the same lines and say, well, we're doing it this time for partisan reasons, that almost assuredly wouldn't stand up. Now, of course, here's the thing. This isn't done, right? I
Isn't
mean,
done.
this is still going up on appeal. And there's actually an interesting quote about that. Um, because part of the question here not only is there these violations of the of the Constitution and of certain voting laws, but there's also this thing called the Purcell I think doctrine, I think is probably the best way to put it. Purcell was another case, and it basically stands for you really shouldn't be changing election maps close to an election. Like
Mm-hmm.
that is strongly, strongly disfavored. Here, if this were like a normal process, there might be a decent Purcell challenge, right? If this was done during the legislative session, like the main session, if this was an again, and I hate to say like if this was a normal cycle of redistricting, right? We have the census, we're going through the process. If this lawsuit gets filed this late in the game in one of those years, they might have a good claim for, hey, it's too late for them to file this. The court here pointed out, because this was addressed in a special session and it wasn't signed into law until August 29th, yeah, plaintiffs kind of acted in a reasonably quick manner to get this teed up for the court to decide. So
Mm-hmm.
they said that, because they acted as quickly as they did, that there was no ban because it was too close to the election. But here's a quote towards the end of the opinion on page 156 of 160. And the court said, and I quote, the Supreme Court has made clear that lower federal courts should ordinarily not alter the election rules on the eve of an election. Indeed, the Supreme Court has stayed a lower federal court's election related injunctions in at least 6 times in the last 11 years. This court is not naive to that reality, but the court is also not naive to the likely unconstitutional realities of the 2025 map.
Mm-hmm.
So the court is essentially saying, look, we agree, we understand that the Supreme Court, the US Supreme Court, usually slaps this stuff down when lower federal courts try to change election laws or election maps. And there's actually some analysis in this opinion that talks about how drawing election, how drawing boundaries for elections, that's the purview of the state legislature. And it's one of the most difficult tasks that they have, and great discretion should go towards them. The court kind of concedes that, but it definitely takes that last shot that, like, we know that we may get struck down. We know the court doesn't like us changing the rules close to the election, but this thing is just so friggin' unconstitutionally, we can't help it.
Yeah. Yeah, they just could not bear to put their name on that. Can you talk about what it says about 32?
Yeah, so that was interesting. So one of the things, for those of you that don't get the reference, Kyle's referring to Congressional District 32, because when the legislature redrew the map, it redrew a great number of districts, and there were a few of them that are here in Dallas County. One of them, which you know, so this is, again, the DOJ specifically listed a handful of congressional districts that were coalition districts, right? There was no single race majority. In addition to addressing those, the Texas legislature also converted 5 other coalition districts into single race majority districts. And those were districts 22, 27, 30, 32, and 35. Now, 30 and 32 are both, at least in part, in Dallas County. And it was very interesting when the court started breaking some of this down as to what effectively happened there. So first, Congressional District 30, um, it was a no single racial group majority district, and the redrawn lines actually turned it into a black majority district, but barely, 50.2%. And the reason that matters is the court pointed out that, as another example of the fact that this was being done on race-based lines and not on merely partisan lines, is that almost all of these districts that were being converted to minority majority districts, it was like 50 point something percent. Like, they were all so close, so barely over the majority, that it indicated like that was the purpose. You redrew up to the point where you got above the 50% and said, okay, no more. So 32 was redrawn to be majority black. And then also, or I'm sorry, 30, and then also in Dallas County, 32. Now, 32, look, 30 shifted a little bit. And, you know, I'm not going to try to hold the map up here. 30 changed a little bit in its shape. 32 became an entirely new congressional district. Originally it was sort of a district that winded its way through like northeast Dallas County, up touching Denton County a little bit, Collin County a little bit. Now this district runs along the north edge, going a little bit into Collin, the north edge of Dallas County, and then way out into East Texas. I'm talking Rains County, Wood County, Camp County, Upshur County,
Yeah.
places most people watching this podcast are going to have to look up on Google Earth. That's going deep East Texas, totally new map. The court notes in here that this is one that flipped to majority white, where prior to this 2025 redrawing of the lines, it was only 43.9% white. But then after it becomes 58.7% white. So a 15% jump in how white the district got. And again, the court sort of juxtaposes this to some of these other districts, like, again, District 30, that only jumped up to like 50.2% black. District 27, that only jumped up to 52.8% Hispanic. District 35, that only jumped up to 51.6% Hispanic, versus 32, which made a huge shift to become more white.
Yep.
The the uh, the court basically said this is all very clear racial gerrymandering from all of these districts. Again, if the argument is we're just following the DOJ letter, well, it didn't even list all of these other districts that you also went ahead and, according to the court, racially gerrymandered, redrew the lines for race-based purposes.
Yeah.
So this is a mix. Like, don't let anybody like talk about this like the Republicans drew a bunch of white majority districts. There were only like I think one that happened in. The rest of them were to give minority groups the majority in the districts. That doesn't matter. It's still based on race, and you can't redraw lines based on race according to this opinion. And I mean, generally speaking, that's constitutional law.
Yeah. And um it's not how we want to do business. It's almost like, I mean, maybe I'm on the wrong track here, but it almost feels like we played into or tried to play into like the DEI type thing to get political cover for doing this. And I'm like, why don't we just stop doing that altogether? Like I just
Well, I mean, look, there were many people on the right that said that redistricting now was a bad idea, full stop,
yep.
right? Because it was, this isn't how we do it, right? I mean, we redistrict after the census. If for those of you at home, I've got a four-legged co-host here. Jordan, you want to make an appearance on the podcast? There we
Oh,
go. Say hi, Hondo. Yeah. All right. Thanks. Hondo did not read the opinion, so I'm not going to let him speak. So
eat it.
the issue here is that it was unpopular to do the redistricting, right? It was politically expedient, but it was unpopular. And so Republicans, I think smartly, didn't want to just come out in public and say, yeah, we're just going to gerrymander the state to add as many Republican seats as we can, because there would have been tremendous blowback from that in the
Yeah.
general.
I I,
Um,
I want to reference last time this happened in Texas. After the 2002 elections gave Republicans full control of the state government. They passed a new congressional map mid-decade, even though the court ordered map was already in place. They had used it. At that point, it flipped from 1715 Democrat to 2111 Republican.
right.
So that that redistricting and later got upheld by the Supreme Court, which was Lulac versus Perry. So I guess I'm assuming
Yep.
that was Rick Perry led that
Yes, it
charge.
was. Right.
Good old Rick Perry, man. Which look, that I'm assuming that was unpopular at the time too, a mid-decade um change up,
Man,
but but
you got to remember 2022, right? 2022 was like very high water Republican times.
yeah,
George W. Bush was an incredibly popular president. This was in the wake of 9/11, right? Like
2002,
re-
yeah.
Republicans had major political capital to burn.
Yeah,
It,
they
it's
did.
it was not like it is under the Trump administration,
They've already burnt everything.
right?
They've used all their oil.
I mean,
Um,
look, Kyle, that's why they needed to do the redistricting,
yep,
because
yep.
the Republicans had such a weak grasp on Congress, and we had no, like consistent coalition of Republicans. We had Republicans not voting with the administration to the point where Trump was like, I need five more friends in Congress.
He did. I will say, right from the rip, he started picking his cabinet members from Congress, which was putting the House Speaker in like a really tight spot. Like literally, you can't take anyone else.
Right.
Like, dude, there's not any more qualified people, but um, we'll see about that. It's funny because this whole thing kicked off with Texas. We're gonna have five more seats. Well, naturally, other Democratic states were like, okay, well then we're gonna have to do that too. We're not just gonna stand there and take that. And California is gonna probably get about five seats. And to my understanding, they're probably not going to get much pushback from their judges,
Well,
right?
here's the thing, Kyle. We just gave them the roadmap.
Yeah, they know what not to do.
Right. Now, all those Democrat states that may want to try to squeeze more seats out, just say you're doing it for partisan purposes. Hey,
Yep.
yeah, the reason we're doing this is for more Democrat seats. You'll be fine. And so
You're
wouldn't that be like the really, really cruel fate where Texas is not able to add 5 more seats, but because the other Democrat states are emboldened to do this, they're and kind of have political cover to do it because the Republicans shot first,
actual cover.
right? And they decide they want to go ahead and do this, they could flip Congress.
They potentially could. I mean,
And that's not
there's
including the like midterm madness we're probably about to deal with.
yes, that is probably going to be the worst of it all. Could be. We'll see. India, so a couple other Republican states that could push out a few more seats, but maybe like one each or something like that. With Indiana, which their Senator Jim Johnson was talking about, Jim Jordan, sorry, was talking about today. Um, and he's really leaning into that to pick up two in Indiana. Missouri, Florida does have a few. North Carolina does have a few. Um, and then I guess Ohio could have like one or two. But again, it takes massive political capital.
Because,
And some of those states are like, dude, we're already providing enough. Like,
well, you also have like North Carolina is not a Republican dominant state.
right.
It's a purple state. It's a very purple state.
Yep.
Um, I'm old enough to remember when Ohio was a purple state. And
Yep.
I don't think that Republicans should just assume that it's going to stay a solid red state. It was Trump that turned it into that. You take
Mhm.
Trump out of the equation, there is no guarantee that Ohio stays as solid red as it is. Same
Yeah.
thing for Florida. I mean, Ron DeSantis has done a great job out in Florida, but
Yep.
there's no guarantee that post Trump Florida stays as red. I mean, you know, this is why you don't do it now. This is why it's like, yeah, I know that everybody wants to please Trump and everybody wants to give him those extra Congress people, but you're really putting yourself out on a limb by doing that.
Yeah.
And in a lot of instances, it's like, okay, fine. Next cycle of redistricting will just be more partisan. And we have
Yeah.
the cover of this is the normal redistricting cycle. But like everybody is in such a desperation to do things right now that they're not really thinking about the political consequences. Because here we have in Texas, we could have all the negatives and none of the positives. We tried to do it, so we take the initial political hit for trying to do it. We take the political hit that it was struck down as unconstitutional
Mhm.
for race-based reasons. And then three, what we try to do it again and get kicked in the mouth. It's just like maybe the US Supreme Court comes in and disagrees and saves it. Maybe they come in and find some sort of clever interpretation. I'm still interested to read Circuit Judge Smith's opinion when it comes out, um, to see what his dissent is and why he feels the way he does.
Mhm.
But I'll be very interested to see what SCOTUS does. SCOTUS may just say this is too late in the game and not even touch whether or not it's unconstitutional. They may just say it's too late to do this. We're not going to disrupt the primaries. If you want to do this for future elections, you can, but the negative consequences of interfering with the elections over outweighs the issues committed here. I don't know.
Yeah. No, I mean, and it is so, I mean, people are already announcing for districts that at this moment don't exist anymore.
Look, CD 32. There are people that are running in 32 right now that if the lines get redrawn, I would be yelling at them at the top of my voice to drop.
Oh yeah, absolutely.
It's just like there are some of these districts that, yeah, if they go back to the old lines, there is no need to be doing the stuff that you're doing. Let's just drop the nonsense and go back to business as usual before. But this is, CD33 is one of those, right? That's another one that affects Dallas County. Um, that's Mark Vesey's district. And so here's the right, like here's the wild musical chairs, I think, um, about some of that stuff is I think because of the new district lines,
Shoot,
Mark
CD.
Vesey is not seeking reelection.
Oh yeah,
So instead, Julie Johnson, who's currently the congresswoman from CD32, is not seeking reelection in 32 and is instead seeking reelection or seeking election in 33, but she is being opposed by Garcia. I can't think of his name right now, and I'm glad. He's a lawyer. His wife's on the Dallas County Court of Commissioners. Domingo Garcia. He's allegedly also running in 33 because Mark Vesey's not seeking reelection. But like 33 is a district that runs from like the heart of Fort Worth, like basically like north of 30, like a strip, and then circles around Irving and then goes down into West Dallas, Southwest Dallas. It's
it
a
is a
very,
wild.
very wild, bizarre district. That one basically cut off all the Tarrant County and they just drug it into Dallas, which is why you've got Julie Johnson and Domingo Garcia now wanting to run for it. If that goes back to the old district, maybe VC stays. If Julie Johnson gets old District 32, maybe she stays in 32 instead of declares for 33. Yeah, there's just so much that's at stake here. It'll be supremely interesting to see what the U.S. Supreme Court does, if anything, with regard to this opinion.
Yeah, and I mean, just again, a kind of a layman view here of the Supreme Court. They do tend to play it safe. I don't really feel like they come out and like with too many surprises, you know? I mean, like they didn't make anything on gay marriage. Um, for instance, in this example, the whole Roe versus Wade, they just said send it back to the states,
Well, so
you
I'm just
know?
going to say, from a con law perspective, that that's arguably the biggest decision in my lifetime
Hmm.
was them overturning Roe v. Wade and turning it back to the states.
Yeah.
Like that was a massive move by the Supreme Court. Like they've done some big things. Here, honestly, I don't know what I would say would be them playing it safe. Is it playing it safe to just allow the maps to like is just allowing the election to proceed with the maps that were adopted by the legislature? Like that kind of actually seems like the safer thing to do as opposed to completely blow up the maps that the state had drawn up. Like the Supreme Court doesn't
Hmm.
do that very often. I actually think that would be more of the like overturning a lower court, not a big deal at all to the Supreme Court. They
Right.
do that all the time. As a matter of fact, if you're a lower court and the Supreme Court grants cert to hear argument, you kind of think there's a good chance that you've got something wrong
Hmm.
because unless you have a circuit split that they're trying to resolve, usually if they accept the case, it's because they think you did something wrong in your opinion and they're going to fix it.
Yeah.
So they don't have any problem striking down the lower court. The question is, does the Supreme Court want to blow up Texas's legislatively adopted map and take that big stand? I think that's actually a bigger stand. I mean, it's also would be a stand in direct opposition to what President Trump wants.
Hmm.
So to the extent that you think that our Supreme Court has any sort of concern with the president's will, I mean, striking this down would be against it. I personally don't think they give a rip about what President Trump wants.
Yeah.
Um, but it is what it is.
Yeah. Oh, absolutely. Yeah, this really does throw a wrench into absolutely everything with the candidates. I mean, because money has already been spent. Money has been gathered in PACs already. Money's been
Mhm.
spent. Donate. I mean, like undoing it, and then when's the deadline to decide when you're going to run? Would have to re-extend the deadline for 60 or 90 days, and you're so deep into the primary season at that point.
Well, I mean, yeah, like what the deadline is in early December.
Yes.
I think
Yeah.
that
It's
the filing deadlines are people are already filing
yeah.
for their seats. Like that's happening now. So there are people that woke up today or that will go to bed tonight that have by this court order. Now, so here's the thing about it that's weird though, right? So congressional districts, these are the only districts that you don't have to live in to run in,
It's cool.
right? All of the Texas districts, the Texas House and the Texas Senate, you actually have to live in that district to run as a representative. For Congress, you don't. So you can be, somebody running in for Congressional District 32,
Yeah.
and it's completely radically redrawn, but that kind of, you know, okay, well, you don't have to be in that district to run in that district. So that's a weird little wrinkle. But yeah, there's all sorts of people that were probably very excited about the prospects of winning a congressional seat that today would be running in a very different race,
Mhm.
i.e., everyone running for Congressional District 32 as a Democrat or a Republican.
Yeah. Absolutely.
So
Well,
that to me is wild. But yeah, that's your point. The Supreme Court could adjust it, could knock it down, and I think one of the things that the governor and the Secretary of State have to be thinking is whether or not now we need to reschedule and delay the primaries.
yeah.
Because it's unlikely that the Supreme Court, look, they might, but I wouldn't expect the Supreme Court to have a ruling on this before the end of the filing deadline. And even if they did, that would be pretty awful to require, somebody to maybe file with 1 day's notice of how the lines have been redrawn. All right, well, that's all for us tonight. Appreciate you, tuning into a better conversation, listening to me ramble about legal things. We hope it was informative. Like I said, we originally were not going to come on tonight, but because the significance and the importance of this case, we felt like we owed it to our audience to do that. I hope it was helpful. Hope it was informative. Kyle, always a pleasure talking with you, man.
Yes, very informative. A lot of things that we went over that were not out there, written by professional journalists, I guess. So I don't know.
No, that's fair. I'm not a journalist, so maybe I look at things a little differently when it comes to how the legal opinions read. I also don't have a deadline for when I have to submit something to, make sure I get my likes and clicks. But well, again, as always, thank you for joining a better conversation. We look forward to seeing you in the future. We hope to see you at a Better Dallas event. Please check out what we're doing at a Better Dallas at www.abetterdallas.com. Also follow us on Instagram, Facebook. You can find out about all the things we have coming. We'll have posts about the podcast and lots of fun events, especially with the upcoming primary season, whenever election day may be. But as always, thank you for joining us.